Okay, good afternoon, everybody. I'm Judge Lambert. Welcome to another oral argument session of the 5th District Court of Appeal. We have one case this afternoon. It's case number 20-1794, Massage Envy Franchising versus Jane Doe, etc., other appellees. The panel today with me is Judges Harris and Traver. You can see them on your screen. You see the clock. It's in my upper left-hand corner. Each side will have 20 minutes to present their arguments. For the appellant, we'll reserve 5 minutes for rebuttal unless counsel tells me otherwise. We are being recorded. We can be watched on YouTube, so keep that in mind with the comments that you make. Also, if you happen to have a phone or any other electronic device that's presently on, please either turn your phone off or put it in mute so it doesn't go off and disturb any of the counsel or the court when we have this oral argument. So if everybody is ready, Ms. DeWolfe, I see we gotten your notice a couple days ago. If you're ready, you go ahead and proceed.
Thank you, Chief Judge, and may it please the court. I'm Diane DeWolfe for the appellant, Massage Envy Franchising, and I thank the panel for accommodating us. I know we've moved this around a couple of times. Your Honors, this case concerns one issue, and that is whether Ms. Doe affirmatively assented to arbitration by clicking a box next to a hyperlink that said, "I agree and assent to the terms of this agreement." Now, normally, a question of whether to enforce arbitration would concern 3 issues, and that would be assent and scope and waiver. But in this case, only one is at issue, and that is whether there was an assent. So what I'd like to do today, and what I plan to address if time permits, are 3 things. Briefly, the undisputed facts that surround the affirmative click and the assent to arbitration. Second, the difference between different types of agreements, the difference between click wraps and browse wraps and collateral agreements and shrink wrap agreements, because that's key here. And then third, I'd like to address where the trial court and the plaintiff's arguments go astray. So first, Your Honor, we have the undisputed facts. Ms. Doe goes into her Massage Envy franchise studio, and she is handed an iPad to complete her intake forms. The intake forms include a button that she was affirmatively required to click in order to complete these forms. That button was on the last page, and it's the one I just mentioned.
That button, counsel, is at the end of another legal section that's entitled My Consent. Is my consent, in your view, a freestanding contract?
Yes, Your Honor. The My Consent section is a freestanding contract with the actual franchisee. The terms and use agreement, which is indicated by the purple hyperlink, is a separate agreement with the franchisor. And
how do you, if my consent is a freestanding contract, how do you accept it? Is it the same way that you accept terms of use?
Well, there's not an affirmative click on the My Consent part of it. That is by accepting everything that is part of the agreement. But the terms of use agreement gives additional terms that apply to the franchisor. And to be clear, both the franchisor is mentioned in the My Consent section as well. And through the My Consent section, Ms. Doe also waives many of her rights against the franchisor. And then
where your argument lies is that by clicking the box, Ms. Doe is accepting the terms of use and the terms of use only.
Yes, that's what the terms of use is, right? By clicking that box. And to be clear, okay, that is on the last page of all of the intake forms. It's on a page all by itself. It's a purple link that she has to click, accepting and agreeing to these terms. And then she also has to put her signature on it before she can get her services and close out of that. She can't close out of her intake forms until she's actually done that. So, and there was no requirement. She hasn't said I was coerced into doing this. She hasn't said I didn't understand what I was doing. She didn't say somebody misled me. I asked them to explain the forms to me and they didn't explain it to me. All she said is that I didn't read it. Okay.
So her signature then goes to what? The terms of use? You said she has to physically sign it. What is she acknowledging by signing?
Well, she is acknowledging the entire intake form agreement. So the first part of the intake forms are things that she wanted to have done with her massage services. They're sort of like a health assessment, if you will. Then it's my consent, which is the forms that tell her what she's legally consenting to with her massage services. It also mentions the franchisor in the consent form, and then the terms of use agreement is an additional click that she agrees to these additional terms of use. And those are specifically with the franchisor. Now, had she clicked that box, which was right there next to her signature, had she clicked the terms of use agreement box, the first thing that would have popped up is, of course, the terms of use agreement in big, bold, all capital letters that say, you are waiving your rights. Please read this carefully. This contains a waiver. It contains binding arbitration and a waiver.
I thought I understood the answer to my question until I felt like you might have just answered Judge Harris's question a different way. So if the signature on the box, you're saying accepts everything, including my consent, or are you saying the signature on the box only accepts terms of use agreement?
My understanding is that the signature in the box accepts everything, including the consent and the terms of use agreement.
So you're reading that statement, I agree and assent to the terms of use agreement, as almost I agree, comma, and I also assent to the terms of use agreement.
No. I think those are two separate things, Judge Traver. I'm sorry if I misspoke. I think the clicking that I agree and assent to the terms of use agreement is a separate thing. That is, she would have to click on that purple hyperlink that is right there next to the checkbox. So she checks the box that she agrees and assents. Now, she's not required to actually read the terms of use agreement. She's required to agree and assent to them. That's what the checkbox says. And then the signature is for the entire agreement, including my consent. That's the way I understand it. Okay. So there's a difference. I'm sorry, did you have a question?
Yeah, I did, but I was talking to myself because I was on mute.
I thought I saw something.
Yeah, it's fancy stuff here. All right, so the signature line itself, there appears to be a signature line, if that's the right term, right below the I agree and assent to the terms of use agreement. Is that what you're referring to? That's the signature for the consent, and the clicking is the separate terms of use agreement?
Well, my understanding is that the click box is agreeing and assenting to the terms of use, which is right next to it. And then the signature box contains the whole agreement.
I mean, isn't the angst that the customer has here is she's read this consent form, and then it says I agree and assent to this terms of use agreement, that she's believing that she's agreeing to what she just read and she clicked it. I mean, it doesn't say I agree and assent to separate terms of use agreement that you should click on to look at. I mean, it doesn't really come out to somebody as a customer when they're sitting there waiting to get their massage that this hyperlink is to an actual 11 or 12 page document. And that seems to be what the angst is that your opponent is having here.
Yeah, and I have to disagree with you, Judge Lambert, because one, she's read through my consent, which is a completely different heading than terms of use agreement, right? Those are two completely separate things.
Those are different words.
Yeah. I'm sorry?
Those are different words, I agree, but I mean, you're suggesting that now all of a sudden there's a terms of use agreement that would catch somebody's eye that says, okay, there's something entirely different that you're also agreeing to. Forget about that. You're going to sign something by tapping right below to the consent form. There's something entirely different that really is not, nobody's given the heads up other than there is 4 words and a hyperlink that they should then put that together that, oh, by the way, there's a significant document that they're being asked to sign and waiving various rights. That obviously is what we're here about today.
Yes, Your Honor, but I think, we're in the 21st century, and when you see a hyperlink, especially one that's in purple and bold and underlined like it was here, this is the 21st century equivalent of turning over a cruise ticket, right? So we all know that if we click a hyperlink, it's going to take us somewhere else. And the hyperlink was right there next to a box, and all she had to do was click on it. And the very first thing that would have popped up is, this is a new agreement. You're agreeing to arbitration and you're waiving your right to class actions. So there's a difference between clip wrap agreements like the one here, browse wrap agreements, collateral documents, shrink wrap agreements. These are all different things. And these are, they've been interpreted all over the United States.
So you believe that Judge Harris is part of the 21st century?
Yes, I do.
I don't know if we should get carried away on this.
Might be the toughest argument you have to overcome here.
Ms. DeWolfe, I, at the risk of beating a dead horse, then, just so I understand your position, if Ms. Doe had simply clicked, I agree and assent to the terms of use agreement and not signed the box, your argument would be that she was bound to terms of use only, even without a signature?
I don't believe she could have closed out the application without applying a signature. I think that's the case. So, but I think the point here and the only issue here is she clicked the box that she agreed and assented to the terms of use agreement. And that's what contained the arbitration clause.
Would it matter if at the beginning of the my consent section, there was language that said, hey, after you're done reading this my consent, you're going to have to sign and acknowledge that you've read this?
No, Your Honor, Judge Harris.
That's what it says, right?
I'm sorry?
That is what's in here, right? In the general consent, it says, please read the general consent and review it to sign below.
And
Why wouldn't she assume that she's signing just the general consent? That's all she's acknowledging.
And that's why I'd like to explain the difference between the click wrap and the browse wrap agreements, Your Honor, because here she did have to sign. She had to do two things. She had to click her assent to the terms of use agreement, and she also had to sign her name to the consent, right, to the entire form. And this is really key. And the trial court explained this. And the best case is a Florida case. It's the Vitacost case. It's out of the 4th DCA, and it explains very clearly the difference between a click wrap and a browse wrap agreement. Okay, this is not a slight difference. This is a neon bright line rule. In browse wrap, click wrap agreements, like we argue, this agreement here is a click wrap agreement. And that is because you have to click this box and you have to agree and assent that you agree and assent to the terms of use. It's very conspicuous. It's right there. It's not at the bottom of the page. It's only the only thing on the page. And Ms. Doe could not get past that screen. She can't close out of it. She can't have her services if she doesn't click that box. Okay.
Do you give any weight to the fact that if she was to click on that, what opens up doesn't say terms of use agreement, it says terms and conditions? Maybe she thought that's something different.
Well, she didn't think it was something different.
It's captioned something different, right? It's not captioned terms of use agreement.
It is captioned slightly different. Yes, I will give you that, Your Honor, except that Mrs. Doe didn't open it at all. She says, I never opened it. I never clicked on it. I saw it. I didn't open it. I didn't click on it. Well, the difference with a browse wrap agreement is that it's not conspicuous. And browse wrap agreements, unlike click wrap agreements, are not routinely enforced, because browse wrap agreements don't require the person to click on anything. And in the Nugent and also the Vitacost case, those were both browse wrap agreements. And
probably a better question for your colleague, but I don't get the sense that Ms. Doe is suggesting this is anything other than a click wrap agreement. It seems like the argument, if I read the answer brief correctly, is that circumstantially this is different than your typical online agreement, in that it's in person, that there may not have been enough time to get it signed, and that we best look to the collateral document doctrine in order to drive our decision. Again, I'll ask the first part to Mr. Cider, but how would you react to those arguments in the answer brief as it relates to the second part of it?
Well, again, a collateral document is a completely separate thing from a browse wrap or a click wrap, right? It's a completely separate, and that is the BGT case that the trial court relied on here. It explained the difference between click wrap and browse wrap, but then it applied the standard for browse wrap or a collateral document. And the BGT case was completely different from this. One, this was homeowners that were paying to have their house built or remodeled, and they were given all the contracts, and it said, I agree to the terms of use. This was a written document. But the terms of use weren't included. They weren't attached. They weren't anywhere. And they didn't even get a copy of the terms of use until years later when they went to sue on that. And regarding whether this was in person or online, this was in person, which is even better than online because Miss Joe had the opportunity to ask questions if she wanted to. If she was confused, she could ask somebody, but she didn't. She wasn't confused and she didn't ask anyone any questions about anything. So, this one, there's really not an argument that it wasn't conspicuous. It was the only thing on the page. It was purple. Counsel has attempted to argue that that was not made clear, but that's just, the purpleness is, if you look at the record, page 378, plaintiff's counsel admits that the terms of use agreement, the hyperlink is purple and it's underlined. Color pictures of this, that was in the appendix at page 378. Color pictures of it appear in the appendix at 188. So there's really no question that it wasn't.
Counsel,
purple.
you're into your rebuttal time. If you want to keep going, that's fine, but they'll just put you on notice.
Thank you, Your Honor. I'll reserve the rest of my time for rebuttal.
All right, very well. Mr. Cider, whenever you're ready, sir.
Good afternoon, Your Honors. Tom Cider with Brandon Humphreys and Berman for Mrs. Doe. As I think we just heard, arbitration is a creature of contract, and this case here turns on whether a valid contract was actually formed. And here, specifically, what this case turns on is whether Mrs. Doe was given notice of the existence of this second contract with the franchisor, Massage Envy.
Can I ask you what I promised I would ask you, Mr. Cider? Is there any dispute here that this is a click wrap?
No, Your Honor. I think you put it well earlier. It is a click wrap agreement, but unlike any click wrap agreement that you see in the cases cited by Massage Envy, it has this sort of idiosyncratic presentation that would have confused a normal user like Mrs. Doe. And the reason why it's confusing, I think it was illustrated pretty well in the questioning earlier, which is it is hard to figure out, what exactly you're agreeing to with the signature versus the checkbox. And in fact, if you were in Mrs. Doe's shoes trying to fill out these forms, when you see this checkbox directly above a signature line referring to a consent section that you just read, what you're going to assume is that the checkbox and the signature are signaling assent to the exact same thing.
Let me ask, if the word separate was before terms of use agreement on the line you had to click, and it said separate terms of use agreement, and your client clicked assenting without reading, you got a much more difficult case here, don't you?
Yes, Your Honor, exactly so.
Because it's telling you that there is a separate document you're agreeing to if you click. So whether she chooses to read it or not, that's her call. If she chooses not to and she clicks, then we probably wouldn't be having oral argument here today. How about that?
Yes, Your Honor, I agree. It could have said separate or additional or more, or it could have at the very least been physically separated from the signature line. But because none of those things.
Once there's an acknowledgement that this is a click wrap, doesn't that settle the issue in the context that at least the body of case law now mostly federally seems to suggest that once we decide it's a click wrap, then you've accepted what's in that hyperlink. I don't necessarily know that I would describe it as a 21st century thing, with all due respect to Ms. DeWolfe, as much as this is what other courts have recognized happens in the contract, in the context of contract formation with that hyperlink document and with that clicked box. Help me understand why that body of case law, which is not one isolated case somewhere in, Idaho, but is all over the country, wouldn't apply in this instance?
Yes, Your Honor. I would start by saying not a single one of those cases involve a presentation like the one here, where you have multiple contracts and multiple contracting parties. And so they are all distinguishable on that basis. And none of the federal cases say that a click is sort of an automatic path to contract formation. But normally the layout of a click wrap is so, sort of straightforward that there is no real room for confusion. And that's not the case here. I'd also like to push back on the idea that this would have been immediately clear as a hyperlink. As Mrs. DeWolfe pointed out, it was underlined, and that there was some debate in the briefs about whether Massage Envy ever established really that this was underlined in color or whether it was black. But even if you accept this idea that it is a purple underline, I heard Mrs. DeWolfe say, it's the only thing that's purple, but that actually is not correct. If you look at the color versions of this presentation, the banner at the top of all the pages is purple. The titles of all the documents are purple. The save button.
What does that necessarily matter, though, if your client says in her affidavit that she knew it was a hyperlink?
I did not read my client's affidavit as saying that she knew it was a hyperlink. I think that she was told it was a hyperlink.
I have it as at the initial brief appendix at 153. I also have that both lawyers agreed it was in purple. Now I understand, and that's at 481 and 487 of the initial brief appendix. Now I know that typically speaking that, counsel can't bind on issues of fact, but it seems to me that regardless of the color of the link, if we've got an understanding that it's a link in your client's affidavit, wouldn't that settle the issue? In other words, I didn't read that your client was confused that it wasn't a link.
Yes, Your Honor. I don't believe that my client said it. I think that she was accepting as a stated fact that it is a hyperlink, having been told, but I don't believe she said, I knew it was a hyperlink or did not know. And I think the practical reality is that my client probably doesn't remember if when she was looking at this.
What it says is, I was able to complete the check-in process without being required to open the hyperlink containing the terms of use agreement.
Yes, Your Honor. So I do think that she's accepted that it is a hyperlink for purposes of the affidavit, but I don't think she's saying I recognized at the time that it was a hyperlink. That's not how I was reading the affidavit. I think what she's saying is, I've been told it's a hyperlink, but I didn't have to open it when I was checking out. There was no requirement, which is what you would run into with a scroll wrap, for example. She didn't have to open it, but I don't believe that she's saying in this affidavit, or that it was ever argued, that she knew it was a hyperlink. And I don't think.
What's the impact of your case if we read that if we read that affidavit to say that she knew it was a hyperlink?
Well, Your Honor, I don't think it necessarily ends our case. In fact, because even if it is a hyperlink that she recognizes as one, she still has, it would be reasonable for her to assume that that hyperlink is leading to, either a restatement of the conditions that she just read, or to further terms and conditions with Massage Envy Winter Garden, the entity that she thinks she's entering into a contract with, and not with Massage Envy Franchising. Because that consent section that she just read told her that Massage Envy Franchising was not a party to the agreement. And so then she is told, to check this click box. And so you have, if we accept Massage Envy's arguments here, it is in many ways affirmatively misleading. It's saying you're not going to be entering into a contract with Massage Envy Franchising. And then she checks this check box, either thinking that it is sort of redundant to the signature, or thinking that she's agreeing to some additional terms with the franchisee. And in fact, it is now being argued that she agreed to a contract with a party that she didn't even know, was involved in the transaction at all. So I do think that even if it is recognizable as a hyperlink, that it doesn't, change the result here. But I do think the fact that the hyperlink wasn't identified as such in the actual agreement, would give rise for a reasonable consumer feeling that would not realize that this was a hyperlink in these in-person forms that she's filling out. Both because there's no direction to click on it, but also because the color isn't blue, it's purple. And there's nothing that would have set that off against the other text. You know, the purple is a color used throughout this. And so there's nothing distinctive about this supposed hyperlink that would make her think that she needed to click on it, or that it was in fact a hyperlink.
I mean, except that it's a hyperlink.
Yes, Your Honor, but you know, text can be underlined without being a hyperlink. And I think it is incumbent on Massage Envy, as the one designing this website, or rather these electronic forms, to make that clearer and more obvious. And the standard that the courts usually apply is, was the notice conspicuous? And I don't believe that under these facts that this hyperlink was recognizable as such, and it certainly wasn't conspicuous to somebody who was trying to fill these forms out in person before their massage.
So if it was in capital letters, terms of use agreement, would that would arguably be more conspicuous, that here's something being highlighted for your client's consideration and signature before clicking her assent. So we're not saying that's the difference between capital and non-capital letters here is the deciding factor, are we?
I don't think so, Your Honor. I do think that there is a lot of things that could be done to make these to make this more conspicuous. I think, though, that what's really missing is, as was discussed earlier, some indication that these are additional terms and conditions that had not yet been addressed by the earlier general consent section. I did want to briefly talk about, Mrs. DeWolfe mentioned that it says underlined terms of use, and that terms of use is not the same thing as general consent. But I think that is asking too much of a reasonable consumer who has read through all of these pages of a contract, which is quite literally terms of use. She's being asked to agree and acknowledge and assent to all these different terms that she will have to abide by if she enters into this agreement with the franchisee. And so terms of use is a good description of what you just read. And as was pointed out, the actual name of the agreement here is not terms of use, it's terms and conditions. And so even Massage Envy, I think, has trouble with the precision when it comes to terms like these. And the reason why is because everyone understands kind of what terms of use and terms and conditions are. And here, what Mrs. Doe would have just read in the general consent section is, in fact, terms of use. It just happens to be with Massage Envy Winter Garden, not Massage Envy Franchising. But that distinction would not have been clear to her, which is entirely the problem as we're arguing here. And so I don't want to belabor any points here. If your honors don't have any further questions, I would just say that our position is that Mrs. Doe was not, in fact, given actual notice of the click-wrap agreement. And as a result, the trial court properly denied Massage Envy's motion to compel arbitration. And we would ask this.
Let me ask the most recent notice of supplemental authority attached the recent Supreme Court case of which you're very familiar with, the Airbnb case. Does that have any relevance to what we're talking about today?
No, Your Honor, it does not. The trial court, I know, did drop a footnote discussing that case, but yeah, as I am very familiar with it, and that the existence of a valid agreement to arbitrate was not at issue in that case. It was about a narrower question of arbitrability, which is not at issue here. And so the disposition of that case doesn't affect the one we have here.
I didn't think so either. I was just curious. But okay.
Questions for you about the trial court's apparent reliance on the collateral document doctrine. To what extent do your fortunes on appeal turn on the application of that document or that doctrine?
I don't think, Your Honor, that they do turn on the application of that doctrine. This court can affirm for any reason found in the record under the Tipsy-Coachman doctrine, but I don't think the trial court was wrong to look to that doctrine, the doctrine of collateral documents, because when you apply this incorporated document principle, what you're really looking at is whether a collateral document was adequately described such that a person would be on notice that they were being asked to agree to that document and that they were being asked to assent to it. And it's really, that's the ultimate inquiry that you're making in electronic contract cases too. It's all aimed at the same thing. And other courts in the electronic contract world have used principles of drawn from the collateral document doctrine to try to draw, analogs. And I think the reason why is because it is similar in that you are referencing a document that is not part of the page or here the agreement that the user's on, and you're asking that user to sort of recognize and be confronted with the existence of this collateral document and then agree to it. So
I wonder about the applicability of that doctrine in the click wrap context. When I review the case law in Florida, at least on that doctrine, I'm struck by how seemingly in every case, and you can correct me if I'm wrong on this, it applies to documents that aren't attached to the contract at all. BGT has no terms and conditions attached to the price quote. Gustafson references conditions on the back of a signature card, which turns out to be blank. Here, it seems by virtue of it being a click wrap, those terms are readily available by virtue of a click to Ms. Doe. And I'm wondering, given that context, how that doctrine applies at all in our case.
Well, I think, Your Honor, the problem here is that, in the cases you described, the user or the plaintiffs are being put on notice that there is, in fact, another agreement, and that on the front end, and it's a question of how much work do they sort of have to do on the back end to track it down. Here, we kind of have the opposite. The problem is that Mrs. Doe wasn't given adequate notice on the front end to know that the other agreement existed. So it's true, had adequate notice been provided here, it would have been easy enough for her to click on the hyperlink. The problem is that she didn't know she needed to. And that's really what distinguishes this case from all the others. And I will admit there aren't any cases directly on point for us, and I would submit there are not any directly on point for Massage Envy. I know both parties have submitted trial court orders from around the country that have kind of come out in both ways, candidly, I think pretty much evenly. But there aren't any appellate decisions addressing this particular Massage Envy presentation. But it is a sort of singular, strange set of facts and the way that this was presented to Mrs. Doe. And that's why, our position is that, be it the regular click wrap cases or these collateral document cases, none of them are really opposite to what we have going on here. And that is the problem in terms of actual notice, or rather inquiry notice being provided to Mrs. Doe.
If we do end up reversing, what do the remand instructions look like? Is it just a remand to send this case to arbitration, or is it a remand to consider other defenses that you raised?
I believe, Your Honor, it would be, without knowing more, I think it would be a remand. We're dealing with issues of law here, so I think any remand order would be directed at sending the case to arbitration, because this particular contract has an arbitrator deciding threshold questions of things like arbitrability. And so that would be for the arbitrator to make in the first instance. The one thing that you can't delegate to an arbitrator is to decide whether a contract exists in the first place, which is what we are here on.
Appreciate all your answers. I don't have any more questions.
Thank you, Your Honor.
Thank you, counsel. All right, Mr. DeWolfe, looks like 3:05 to go, or 4:38 to go. Excuse me.
Thank you, Your Honor. Just a few points on rebuttal. Judge Traver, I think you mentioned that there are cases all over the country. And then Tom, the counsel, was also correct that there are no appellate decisions as of yet, but there are currently 2 trial court cases, to my knowledge, in Florida. The one at issue here, and then the one that we have cited in our brief, Doe v. Massage Envy, which was a case out of the 15th Judicial Circuit in Palm Beach. Now, that particular case is, as I said, has been cited in our brief, not in the supplemental authority. And it is directly on point on all of these issues we've discussed today, and it talks about the exact same issue. So I'd urge you to look at that when you're deciding this, because clearly the order that we have here, which appears to be the only competing order in Florida, went astray with the collateral documents and applying the Doe-Nat, which is a delegation case and has nothing to do with quick wrap agreements. I think it's also important to note that the separate entity cases that plaintiff has relied on are really completely different from the separate entity in this case. If you read through the my consent part of this, Massage Envy franchise has been introduced. It's also states in the my consent form that MEF is not responsible for her service this day. So trying to say that MEF came out of left field here and she would just have no idea that this terms of use agreement would have anything to do with MEF is really not to be believed. The cases that they rely on, and there are three, it's McKee v. Audible, Lee v. Intellius, and Schnobel. And in all of those cases, McKee, for instance, he was trying to load some software into his Echo, and by clicking on the I agree button, he signed up unbeknownst for a $20 a month agreement with Audible, which was a completely different company that provided different services. Lee v. Intelliance is the same thing. Mr. Lee went on to get a background check, and there were two buttons available: yes, display my results, or no, display my results. He clicks yes, display my results, and that signed him up for $20 a month of family protection that with a completely different company he never bargained for. That's not this case. There is nothing misleading here. We're not trying to hide the ball. The link was on the very last page. The fact that it's purple instead of blue is of no moment. Mr. Cider was talking about the fact that there were other things on the page that was blue. That's the heading. Massage Envy's colors are purple. The only thing in the body, the substance of the very last page is the signature block and the link with the checkbox, which happens to be purple. And these are the types of agreements that are regularly upheld. Judge Traver, as you noted, quick wrap agreements are generally always approved of by the courts. Was it conspicuous? Yes, we just went through that. We know what quick wrap agreements are. We click on them all, or we know what hyperlinks are. We click on them all the time because, we want to read that article. So we have to accept cookies. Do we know what the cookies are? No. We click on it because we want to buy our purchase, or we want to pay our bill, or we want to get our massage service. But I think it's also important to note that Miss Doe did not have to click on this. She had to click on it to get her service, right? But she didn't have to agree to arbitration. She also had an opt-out provision, and that was very simple. She had 30 days, and all she had to do was send a simple email to info@massagenv.com and say, I opt out. She doesn't have to say anything else. And that was a very simple procedure, but she didn't do that either. She chose not to read it, and she clicked on the link agreeing and giving her consent. So, Your Honors, we would ask that you reverse this case and that all trial courts proceedings be stayed and be sent to arbitration.
Okay. All right, counsel. Thank you very much. Well argued today. We will stand in recess and we'll issue an opinion or decision. We'll get to it. All right. Have a good day. Take care.